Just momentarily, I want to bring, of course, to talk a little bit about this, our legal analyst. We had the defense attorney, Mark O'Mara, spending more than 3 hours delivering his closing argument, and prosecutor John Guy, he had an hour for his rebuttal, and I want to get some reaction to this. We've got criminal defense attorney Faith Jenkins and Mark Nejame. Mark, first of all, the defense started its case with this knock-knock joke. It felt pretty flat there. Now he ends it talking about this is a simple decision. This is all about self-defense. Was he convincing?
I think he was very good, but I think that the defense should have focused a little bit more on a couple of key points. One of them is manslaughter. I think, you know, they focus a lot on second-degree murder, and that's important, of course, but they've got to focus. They needed to focus on manslaughter because that's going to be the probability if the jury comes back with anything. And I think that needed to be hammered a little bit more. I also think that a little bit of passion on some of the key points that he wanted to make. He was very folksy, very professorial in his presentation. I thought it was excellent with all the pictures of the witnesses because it allowed people to be talked about who the jurors might have forgotten. I think that was very effective. But I think a couple of points needed to be hammered home. And so I think he did a very good job. I think there's plenty of reasonable doubt in this case, but I am concerned that there wasn't enough focus on that manslaughter, which is where the concern needs to be for the defense coming back from the jury.
And Faith, how do you think this is going to play with a jury of 6 women when you had John Guy talking about the greatest fear that a child has is of being followed, going home, being followed by a stranger in the dark? I imagine that he is probably looking to those jurors who are, 5 of the 6 are mothers, and thinking this is something that they can relate to.
That's exactly right, because as a mother, you expect your child to be able to walk to the store and buy snacks and make it home without being shot and killed. That's going to resonate with these mothers. The emotion in this case is all on one side. And John Guy brought that out today. Of course, there are unanswered questions. He said it directly. We can't tell you exactly what happened in that altercation when Trayvon Martin and George Zimmerman met. But here's what we can tell you. George Zimmerman followed him. He called him all of these names. He didn't know him. All of these other incidents had happened, and he was frustrated. And he said they always get away. And then guess what? This one did not get away because he shot and killed him. Right. John Guy made those points, and he made them well today.
And I want us to play what John Guy said, something that really resonated with a lot of people, stood out. Just listen to this, and then, Mark, I'll get your reaction on the other end.
Trayvon Martin may not have the defendant's blood on his hands, but George Zimmerman will forever have Trayvon Martin's blood on his. Forever.
Weigh in, Mark. That was a pretty powerful moment.
Oh, I think, look, he's got a great command of the words and of the English language, and I think he was an excellent, excellent speaker. No question about it, you know, A+ as far as his opening and his final summation. With all that said, I think it's a bit patronizing to women generally and to the women on this jury. Fathers are equally concerned about, you know, their children not being able to make it home. Of course, he's playing to maternal instincts, but, you know, where does that play to the issue of reasonable doubt? Where are the facts? The fact of the matter is I think that this case is riddled with reasonable doubt, and it's a bit patronizing to think that these women on the jury are unthinking and that they're purely emotional. Of course they're going to hear the facts, and they're going to listen to the facts, and of course they're going to be empathetic, and they're going to have some sympathy and some empathy, without question. But to suggest that they're brainless and that they're not going to listen to the facts just because they're women and they're going to be simply only dealing on emotion, I think is really an insult. These jurors, who happen to be 6 women, are going to listen to the facts. They're going to factor in the emotional aspect, but they're going to listen to the facts, and they're going to make a determination. And if they follow the facts, there's reasonable doubt riddled throughout this case.
I haven't heard anybody suggest that they're not using their brains, that they're brainless here and they're purely emotional. Have you heard that, Faith?
No, but there is an emotional aspect to this case. When you have a 17-year-old with snacks, with no gun, walking home, minding his own business, and he ends up dead, of course there's an emotional aspect. He just turned 17 3 weeks prior to him being shot and killed. And let me talk about the reasonable doubt aspect of this. Here's what the prosecutor did today. There are 2 people involved in this encounter. One of them is dead. He's not here to tell his side of the story. Of course, there are going to be unanswered questions. The prosecutor essentially told this jury, don't reward this defendant for killing the only other eyewitness to this encounter. Look at the evidence. Yes, you can draw inferences here from what we know. And the prosecutor's asking the jurors to draw those inferences.
Faith and Mark, I'm told we got to take a quick break here, but obviously we'll bring you back because we've got a lot to talk about in this. And in the meantime, we are watching, we are waiting. The jurors are taking a lunch break, but when they come back, they are going to get instructions very soon, and then they will start deliberating on the fate of George Zimmerman. That up next.
He didn't want to know about Stand Your Ground. Didn't want the police to know he knew about it. Stand your ground? What's that? And let me suggest to you, in the end, this case is not about standing your ground. It's about staying in your car like he was taught to do, like he was supposed to do. And he can't now cloak himself with the noble cause of a neighborhood watch coordinator, violate its cornerstone principle, and expect you to absolve him of his guilt.
That was Prosecutor John Guy on the prosecution side just moments ago. Mark, weigh into that. That was one of the main issues, of course, from the very beginning, is whether or not he had any right to follow, to pursue, or to defend himself, as some have suggested that he was doing in this case.
Well, that's where the prosecution has to go, because the reality of it is their position is that but for him leaving the car, none of this would have happened, and that started this whole process into motion. So that's, of course, where the blame needs to lie. So what the defense has had to do is to segregate that. I mean, look, if somebody didn't get up in the morning, then all of this wouldn't have been set into motion, and one can keep on pointing the finger and doing the blame game. The issue, though, is really, did the state prove that George Zimmerman initiated the physical confrontation? And did they prove that he was unreasonable in his belief that he was facing death or great bodily harm? Did they prove that through the evidence? And what I see is, what concerns me the greatest, and I think the defense should have focused on it more, is the state changed up its game plan really on the day before their closing. From the beginning, on their opening statement, they said George Zimmerman was a top Trayvon Martin. And by their representation, their demonstration with the dummies, they showed not even that scenario. They showed George Zimmerman being, Trayvon Martin on top of George Zimmerman. So they all but conceded that point. So they changed up their game plan. When you got to change up your game plan 90% through the trial, you got troubles.
Faith, do you think the prosecution has troubles? We heard, well, there are a couple of things I want to ask you, but first of all, I'll ask you that.
Well, they've had trouble from the beginning because this is a very difficult case. It's an uphill battle here when the only living eyewitness in this case is now George Zimmerman. But that was a great point that the prosecutor made about neighborhood watch. What have we heard repeatedly from the witness who testified? You use your ears and your eyes. Your ears and your eyes, and it is clear that George Zimmerman went far beyond that. There's this notion that somehow he had the authority and the right to stop and question Trayvon Martin. Trayvon Martin had every right to be where he was, walking where he was. He does not have to answer to George Zimmerman. He is not a police officer. He is not a person who, in a position of authority, who can stop Trayvon Martin. He had every right to be here and not answer a single question he asked.
We agree with that, but that wasn't the issue. We agree with that, but that's not the issue. That's the red herring that you're throwing out. It really has nothing to do with that. Nobody's saying that Trayvon Martin had every right to do exactly what Trayvon Martin was doing. He had a right to go to the store. He had a right not to be killed. He had all that.
George Zimmerman didn't think so.
That. But what happens is
Mark, that is a clear issue in this case.
Hold on. I'm not dealing emotionally. I'm dealing with the facts. Did the state prove beyond a reasonable doubt what happened concerning that initial confrontation? What I'm talking about is legally, not passionately, not emotionally, not morally. Legally, did the state prove beyond a reasonable doubt that Trayvon Martin was, in fact, attacked by George Zimmerman? Did they prove that George Zimmerman was not in fear of death or great bodily harm? And my answer is simply, no, they didn't prove it.
All right,
I understand that.
Faith, jump in here. Okay, thanks, Mark. Faith, jump in here if you would, because, yes, I want you to button this up and tell us as well what we expect from these jurors. Is 6 women, 5 of the 6 who are mothers.
We can expect them to listen to the law and listen to the jury instructions and decide the case based on the facts and the law. They're not going to look just at, I think, what the defense wants them to look at, that encounter, that altercation, that physical encounter. They're going to take into account the entire narrative of what happened. And Mark, you and I disagree on this, because the fact that George Zimmerman was Neighborhood Watch, never identified himself to Trayvon Martin, was carrying the loaded gun. When he got out of the car, he knew he had the loaded gun. He'd already called the police. He had all the power behind him. And the inference is he had the incentive and the motive to stop and confront Trayvon Martin, based on everything he said on those calls when he saw that young man.
And finally, one last point here, if we can. One of the things that Mark O'Mara made a point, and this was something that he argued with the judge previously because she did not give the jury these instructions, is that following someone is not illegal. That was an important point to make here, because the emphasis has been different on these two sides, whether or not Trayvon Martin was essentially being hunted down, if you will. What was the significance, do you think, Mark, that he was able to actually get that in and make that point?
Well, it's exactly what we've been talking about. It's not illegal to follow anybody, and that's the challenge here. Look, again, I'm not speaking morally, and I'm not talking with a civil lawsuit, but criminally, you know, we ask people to be neighborhood watch. We ask people to keep an eye on their neighbors. We ask people, look what happened in Cleveland. You know, if people call in, we want people to do that. Now, did he go too far? That's not the discussion I'm having right now. That's for a civil trial. But he is allowed legally to do what he did. Now, with that said, that's why the defense brought up, what did Trayvon Martin do for those 4 minutes? Look, it's beyond a tragedy that a 17-year-old kid is dead. It truly, truly is. I'm simply giving you a legal analysis saying that, did the state prove what all the emotions are screaming to?
All right,
and I
Mark,
don't see where they brought out the facts or the evidence that they did.
Mark and Faith, we're going to bring you guys both back so we can talk a little bit more about this. Obviously, we're waiting for the jurors to come back. They'll get their instructions. Then they'll start deliberating in earnest. You see the seal there. That means they are still on their lunch break, but in about 40 minutes or so, we expect them to come back and the judge to give them their instructions here. And we're following that every moment, step of the way.
The jury is deliberating in the George Zimmerman murder trial. We're back now with our legal panel, and we want to discuss what we saw before the judge gave out those jury instructions and the jury went back to begin deciding George Zimmerman's fate. Today we saw closing arguments by the defense, and then we saw a rebuttal closing argument by Deputy Prosecutor John Guy. Very dramatic, I thought, closing argument that he gave. Let's listen to part of it.
This case is not about race. It's about right and wrong. It's that simple. And let me suggest to you how you know that for sure. Ask yourselves, all things being equal, if the roles were reversed and it was 28-year-old George Zimmerman walking home in the rain with a hoodie on to protect himself from the rain, walking through that neighborhood, and a 17-year-old driving around in a car who called the police, who had hate in their heart, hate in their mouth, hate in their actions. And if it was Trayvon Martin who had shot and killed George Zimmerman, what would your verdict be? That's how you know it's not about race.
Imagine, he was saying, if their roles were reversed here. Sunny Hostin, you were in the courtroom during this time. Did you get a sense of how the jury was reacting to what Guy was saying to them?
You know, he had them at hello. He had already established a rapport with them because he gave a very forceful opening statement. His cross-examinations were very colorful. Remember, he was the one that was straddling the mannequin on the floor in front of the jury, with many of the jurors standing up to see him. So he already has this rapport with the jury, and when he got back up, I've got to tell you, a few times they looked at some of the exhibits he was referencing, but every other time their eyes were fixed on him. They did not look away. I hadn't seen that kind of reaction with any of the other attorneys during any of the other statements or arguments. And so I think that they really, really honed in on what he had to say. It was very, very impressive. And yes, he did argue from an emotional standpoint in some ways, but he also argued the evidence as well. And so I think this jury certainly seemed to connect with him. In particular, we know that there are 5 mothers on this jury out of the 6 women that are on the jury. When he described a child's worst nightmare being followed in the dark, in the rain, by a stranger. I'm a mother of a boy. It resonated with me. I cannot imagine that it didn't resonate with the mothers on the jury.
And so he said that, use your hearts. That's what we didn't hear that coming from the defense when we heard their closing argument. Let me bring in Faith Jenkins. You're a prosecutor. You've served in this capacity. He said there something that struck me, because he said this isn't about race. And yet, to me, that sort of belies that the prosecution is concerned that perhaps it is about race and that jurors may not necessarily identify with Trayvon Martin, or, as we heard from Bernie De La Rianda, they may not identify with what you could argue is their star witness, Rachel Jeantel. Do you think that's a concern? Is that the right way to read that?
I think they're being very careful here with their phrasing to not make it that issue in front of this jury, and just look at the facts and the evidence and what they've presented and base the case on that. John Guy's presentation, we're taught as prosecutors, in order for a jury to believe in your message, they have to believe in the messenger. And he stood there with such conviction. You could tell he really believed what he was telling these jurors today. And when he talked about that one particular issue, they've used the word profiling a number of times in this trial without using racial profiling, but the words profiling. These jurors know what that means. They know that when they say Zimmerman profiled Trayvon Martin, he didn't profile him because he didn't like the kind of candy he was carrying, but it was because of how he looked and how he was dressed. But at the end, they came back and they told this jury, look at the evidence, look at the facts. Doesn't matter if it was George Zimmerman, if it was Trayvon Martin, right is right and do the right thing.
Don Lemon, I know you have some thoughts. How effective do you think this closing argument was?
Well, listen, I'm just going to be honest here. If someone who I haven't watched this from gavel to gavel, as you say, I'm a layperson here, and I'm watching all the legalese and hearing all of you talk about this. To pretend that emotion is not part of a trial or jury is, I think, just completely disingenuous. As someone who has been a juror before, who has served jury duty, and you said decide on certain things, people go into a jury room and they decide based, yes, upon facts, but human beings are not devoid of emotion. And so they also base their decisions on emotion as well. There is a reason that there are 6 women who have children, 6 mothers on this jury. There is a reason that the parents on both sides have testified here about whose voice they're hearing, about what kind of child they have. There is a reason for all of that, and that is, emotion is a big part of that reason. And there's a reason that the prosecution at the very end relied upon emotion to give the jury in the end. So to pretend that emotion doesn't play into this, I think, again, is disingenuous. I'm not a legal expert, but I know when those people go into that room, there's going to be emotion in their heart, and they're going to weigh their decision on the facts, of course, but they're also going to weigh their decision on being a human being, and part of that is being emotional.
And the defense certainly knows that in that capacity they are at a deficit. One of the ways that we saw Mark O'Mara, the lead defense attorney, trying to combat that was by using a block of cement. In his closing argument, he was saying that is a deadly weapon, basically saying that Trayvon Martin had a deadly weapon in addition to George Zimmerman. We'll see how effective our panel thinks that was right after a quick break. Now, we've obviously long heard, we're going to put this to our panel, that George Zimmerman had a gun and he was up against an unarmed 17-year-old. The defense, very sensitive to this, trying to make the jury think about this in a different way. Listen to what Mark O'Mara said this morning during his closing argument.
Now, I'll be held in contempt if I drop this, so I'm not going to do some drama and drop it on the floor and watch it roll around. But that's cement. That is a sidewalk. And that is not an unarmed teenager with nothing but Skittles trying to get home. That was somebody who used the availability of dangerous items from his fist to the concrete to cause great bodily injury. Not that it's necessary for self-defense, but great bodily injury against George Zimmerman. And the suggestion by the state that that's not a weapon, that that can't hurt somebody, that that can't cause great bodily injury is disgusting.
The defense clearly sensitive here to what we have heard from the prosecution, that George Zimmerman was armed with a gun and Trayvon Martin was armed only with iced tea and Skittles. Tanya Miller, a former prosecutor, current defense attorney, do you think this was effective, or was this too much?
I thought it actually fell a little flat. The problem with this demonstration was, one, the state never said that the cement couldn't hurt you. What they said is that George Zimmerman is exaggerating the extent of his injuries, and that Trayvon Martin didn't use the concrete and the cement in the way that George Zimmerman says he did. And I think the state effectively pointed out in the rebuttal all of these lies and inconsistencies in his statements, including the injuries, and the defense did not effectively deal with that in their closing argument. And I think this was a feeble attempt to do it. It just sort of fell flat. Of all the things you can show sort of righteous indignation about and be disgusted about, that just didn't seem to be one of them.
What do you think, Trent? Do you agree with that? I mean, you heard from the state. They pointed out Zimmerman said he was hit dozens of times, 25 times, but they say the injuries on the back of his head were not consistent with that.
You know, look, I couldn't disagree more, frankly, and with regard to what Tanya said, you know, with regard to all these inconsistencies that we keep hearing people discuss, I'm not sure what they are. And to the extent they exist, they're really minor. In fact, even the chief lead detective in the case said that the inconsistencies from George Zimmerman's statements have all been minor. And when you talk about these injuries, look, let's call it what it is. I don't know that I'd want to have the kind of bruises on the back of my head and the gash that George Zimmerman had on the back of his head. I wouldn't want to have that and have someone call that insignificant. And remember this. Look, if a woman, for example, walks into a police station and she presents with those injuries on the back of her head to a police officer, she will, by definition, that will be considered great bodily injury, and the police will go out, they'll arrest whoever did this. If it's her husband, it's domestic violence. That's the standard. So we can't take the standard in this case and look at it and say that George Zimmerman's injuries weren't severe, they weren't significant. And then in another kind of case, I do this every day, those kinds of injuries and less, and Sonny will attest to this, those kind of injuries and less will present in any court of law, in any police station in every county in this country as great bodily injury. So the reality is you may not consider those kinds of injuries to be enough for George Zimmerman to have reacted with a gun, to have shot Trayvon Martin, but strictly as a legal matter. He had the right to do that under Florida law because he presumed that he was going to face even greater injury, even more significant injury. And remember, the law doesn't require that there be any injury at all. So whether you like George Zimmerman or not, and I certainly understand folks who won't, the fact of the matter is that this is significant injury, and it presents as such.
And as we heard, the jury will consider, did Zimmerman respond reasonably? That is very much at the heart of this. The jury continuing to deliberate in the George Zimmerman trial. We'll be right back in just a moment to answer the question of how long it might take them to come to a verdict. The jury in the George Zimmerman trial now behind closed doors, deliberating, considering his fate, as we expect them to do, possibly for some time to come. The last thing they heard before those jury instructions was a rebuttal closing argument from the attorneys for the state, the prosecution. Here's part of it.
This case is not about race. It's about right and wrong. It's that simple. And let me suggest to you how you know that for sure. Ask yourselves, all things being equal, if the roles were reversed and it was 28-year-old George Zimmerman walking home in the rain with a hoodie on to protect himself from the rain, walking through that neighborhood, and a 17-year-old driving around in a car who called the police, who had hate in their heart, hate in their mouth, hate in their actions. And if it was Trayvon Martin who had shot and killed George Zimmerman, what would your verdict be? That's how you know it's not about race.
I want to bring in Trent Copeland. He is a defense attorney. And Trent, if you're sitting there, put yourself in this role. If you're the defense attorney and you're listening to the prosecution give that argument, it's the last thing really of substance besides the jury instructions that the jury hears. Are you concerned that it's effective?
Of course I'm concerned, because look, it's the last thing the jury's going to hear. It's going to resonate with the jury when they go back in that room. But what I'm also hoping is that the jury is going to take back one of the instructions that the court gives them. And that is, you can't decide this case on emotion and anger. You have to look at the facts of this case. And remember, when it was the defense's turn to present their closing statement, they dissected the evidence almost with the tactical precision of a doctor dissecting and going through a surgeon's heart. They really went through every piece of evidence. By contrast, it was the prosecutor that was asking for this jury to use their emotion, to use their passion, to respond in a passionate way, and to essentially not like George Zimmerman. And that's a problem. And essentially, they're asking this jury, the prosecution is, for the jury to simply say, look, ignore the evidence, ignore what you've seen. We know that it was George Zimmerman that put all of this in motion, and it was George Zimmerman that started the confrontation. Ignore the problems that we have in our case, but look at the facts, use your common sense as mothers, as daughters, as people who want to feel for this family. And there's no question that's going to resonate with this jury, but I can't say that it really is going to carry the day, nor it should.
All right, let's bring in Tanya Miller. You actually sort of thought this was a really intriguing device, that this was something that may have really worked.
Well, I think what John Guy was doing was really interesting here, because what he doesn't want this jury to do is go back there and be divided, right? And the issue of race and the role that race plays in this case, or might play in this case, is a divisive issue. So he's telling this jury, look, this case isn't about race. This is about what's right and wrong. And I thought that was very smart for him to do. But look what he also did very subtly. He also said, now, let's not be divided about race. Let's make this a question about what's right or wrong. But I want you to just think for a second. If the shoe was on the other foot, would you really struggle the way that the defense is arguing you should struggle about what happened here? Would you have the sort of doubts about self-defense that the defense wants you to have now? I thought it was very effective.
He gives them, in a way, a mental device if race is playing an issue, if, for instance, they identify more with George Zimmerman than Trayvon Martin, or the witnesses for George Zimmerman than they do for Trayvon Martin, that they can maybe perhaps use this device to dismiss that in their judgment.
Exactly. He does that so smoothly and so effectively without making race the divisive issue that we kind of see it playing out as on the outside of the jury room.
Tanya Miller, thank you very much. And we will be right back after a quick break. We'll have much more analysis ahead.